Hello, Mr. Hazziq. My printing machine goes down. Can you have my spare part ready?
Yes, sure, Mr. Azrul. When do you need the spare part?
I need it as soon as possible because I can operate my factory.
Alright, I will send it to you before this Wednesday.
Okay, I got it. Hello, Mr. Hazziq. Where is my spare part for the machine?
Sorry, Mr. Azrul. I cannot send you this week.
You already said that you will send it to me last Wednesday, but there is no news from you.
Sorry, Mr. Azrul. I'm so sorry.
You know how much I had lost due to your delay? I want to claim my loss from you. I take this to the court. So, as for this scenario, the issue is whether the remedies for breach of contract made by Mr. Azrul is valid or not. And the law involved is the issue concerned with the remedies for breach of contract. According to the rules in the section 74, whereby the injured parties entitled to damages arising naturally, and if he claims special damages, he must show that there is special loss is likely to result from the breach at the time making contract. According to the rules in the section 74, Mr. Hazziq is bounded to the contract with Mr. Azrul, where he should have sent the spare part on time, and Mr. Azrul can get remedies if Mr. Hazziq breached the contract. Therefore, a plaintiff cannot claim remedies for breach of contract if the defendant sent it on time in good condition, or the plaintiff did not show any damages arising caused by the breach of contract. Based on the case Tam Chio To v. Associated Metal Smelters Limited, the defendant had a valid contract with the plaintiff, and the defendant breached the contract, which makes plaintiff can get remedies for breach of contract made by the defendant. The defendant are liable to pay loss for the plaintiff. Application: based on the law above, remedies for breach of contract made by Mr. Azrul is valid. The reason being, there is a valid contract between Mr. Azrul and Mr. Hazziq, and Mr. Azrul lost due to breach of contract made by Mr. Hazziq. Therefore, Mr. Hazziq is bounded to the contract with Mr. Azrul. However, the remedies for breach of contract will be invalid if Mr. Azrul did not have any losses and Mr. Hazziq sent the spare part on time without any problem that caused damages to Mr. Azrul. For the conclusion, in conclusion, remedies for breach of contract made by Mr. Azrul is effective because there is a valid contract between Mr. Azrul and Mr. Hazziq. So that's all from me. Thank you.